Welcome back to the Weekly Friedman, your source for the most essential information in the default industry. I'm Adam Friedman, managing partner at Friedman & Vartolo, and joining me today is Hillary Prada, senior associate at Friedman & Vartolo. Hillary has extensive experience in the New York default process, and most pertinently for today's episode, is regularly called upon to handle complicated service of process issues and surrogates proceedings. Thanks for joining us today, Hillary.
Of course.
So navigating the New York foreclosure process can be challenging under the best of circumstances, but when a necessary party to the action has passed away, it adds a layer of complexity that requires additional knowledge and meticulous attention to detail. A key variable to consider is whether the individual passed away intestate, meaning without a will. Okay, so can you walk us through the steps that need to be taken when a necessary party has died intestate?
Absolutely. So we do two things right away. We obtain a copy of their death certificate. This is needed to affirmatively demonstrate that they have in fact passed away. The second thing that we do is we reach out to our service of process vendor and we get what's called an affidavit of heirship. We use this to ascertain the heirs that we can identify of the decedent.
Okay, so they're going to pull whatever heirs they can identify. Like they might find no heirs. They might find 50 heirs.
Exactly.
Okay.
So what they're trying to do is determine the relationships that these heirs that they identify might have with the decedent. So ideally they're looking for a spouse or children or parents.
Okay.
Anything that has a close relationship to the decedent that would potentially have an interest in the property by operation of law.
And then we're naming these individuals or bringing them into the action?
Exactly.
Okay.
So what we're doing is we are getting this affidavit of heirship and we then are running searches on their judgment creditors.
Okay.
And then we are going to add them to the action as well as the unknown heirs of the decedent.
Okay. So in essence, anyone that may have an interest in this estate, right? We're naming them as parties as if they're a normal interested party, and we're going to serve them and treat them exactly the same.
Exactly. And then we're also going to take their unknown heirs and name them as well, just because if we can't ascertain for certain that these are the sole heirs of the necessary party, we want to publish on the unknowns to cut off any potential interest that they might have in the property.
I know this process can vary county by county, especially downstate. Could you walk us through some of the more notable county requirements?
Absolutely. So some counties require that once we determine that a necessary party is deceased, that we have to commence an action in surrogates court. Some of these counties, Queens, Richmond County. So what we need to do is we do a creditor's petition seeking the appointment of an administrator for the estate of the decedent. Certain counties require certain things that others don't. For example, Richmond County, they require that the petition is signed by the investor, not the servicer, which can be complicated.
More complicated.
Additionally, Richmond can sometimes require a genealogist, that we have to obtain the services of a genealogist in order to determine who the heirs are.
Are there a lot of genealogists out there?
No, but there are some that because Richmond has started to require this, they know that this is a service that they're required to provide. So we have to obtain their services, which is obviously an additional expense as well. Additionally, Ulster County is another one. They require a copy of the funeral bill for the decedent. So we submit that with our petition.
Which is also complicated to find, I imagine.
Exactly. That sometimes we have our service of process vendor, they'll obtain that while they're doing the due diligence for the decedent.
Okay.
But it's just another step and just something else that sets that county apart.
Are they going to the funeral parlor?
Yes. They contact the
funeral
director.
parlors will give the information?
They will, yeah.
Okay. Clearly there's less work if the surrogate proceeding has already commenced. Mm-hmm. Is this something where if that proceeding is ongoing, are we able to commence or proceed with our action, or do we have to pause, or how would that work?
So we can commence the action. What we would do is, if the action has been commenced by a family member of the decedent, that's obviously in a more ideal scenario, because then we can really know, the more likelihood, that those are the actual known heirs of the decedent. So we wouldn't have to publish ultimately, which is very helpful too. But we can commence and we can name them as a possible administrator of the estate. And then once a decree is issued, which actually appoints them as administrator, then we can change our caption later to reflect them in their proper capacity.
All right, to recap, the goal of any foreclosure action is to convey clear title at REO. When a necessary party has passed away, the process to foreclose becomes slightly more complicated, and it's vital that the firm handling the proceeding on your behalf is knowledgeable and experienced in the process. Put another way, if you're facing an issue where you have a deceased necessary party, you should probably email Hillary, and we'll make sure that information is included on the screen. Thanks for joining Hillary and I on the Weekly Friedman, your source for the most essential information in the default industry. If you have any questions, comments, or suggestions, please leave them in the comment section below. Looking forward to seeing you next time.